instructions for the period in which persons may present their claims on the property, as well as the date for which the first hearing, the first court hearing is scheduled. This is the way to make public that an announcement that a procedure regarding some real estate or something else is going on, and persons who has some interest or claim to have possession over the real estate may file a claim. The claim is based on the property law of the Republic of Bulgaria. I would like to say some words about the reuse of confiscated property. According to the Bulgarian law, at least 30% of the value of the property seized for the benefit of the state is used for social purposes, and the terms and conditions are determined by an act of the Council of Ministers. When an asset is confiscated with the final decision of the court, the Bulgarian legislation allows the property to be provided for the needs of budget organization, which financing it depends on the state budget. Movable property, this is, I think, the property which is more often claimed by this organization. A register is supported by the National Revenue Agency, and when somebody wants to use this car or some vehicle or something else, they may claim this use, and the Council of Ministers may issue a decision for this reuse of the property. This is the main issues of the Bulgarian legislation in the area. So I am ready to answer if there are questions about that.
Is there any questions? I would have just a small doubt related to the procedure of for the restitution of the 50% amount to other states. You mentioned one case, but then you don't know if there are other cases, or you know that there is just one case that you are aware of this happening. Sorry, I think she's frozen as the assets. So maybe we have some problems with the connection of Mrs. Ilieva. Yes. Well, we hope that she will be here soon. Consequently, we should have a small break of 10 minutes before the speech by Antonio Balsamo and the intervention by Ukraine and Moldova that will close our workshop. So we will gather here again at 3:30 exact p.m. Okay? See you in 10 minutes then. Thank you. Hi, Mrs. Eleven. Yes, there was a technical problem, but as soon as we will gather here again, we will continue with the questions and the speeches. Thank you very much.
Matteo? Matteo Balsamo is able to speak by 10 minutes. 50 after 3. 40 after 3. Matteo? Mi sento. Ma proprio, Matteo, mi sentite?
È al telefono, arriviamo.
Quindi lei ha questa disponibilità dalle 15.
Sì, no. I would like only to say that Balsamo is able to speak in 10 minutes, not now. So maybe we can start with.
He is talking with Balsamo.
Va benissimo.
Oh, ok. Course that we can start with now we have Ukraine and after Basa.
Hi, I'm sorry, Prosecutor Balsamo just called me saying that it has a tiny time for the intervention that is from 15:40 to 4 p.m., from 3:40 to 4 p.m. So I presume that the best option is to wait for him 10 minutes, so to extend the break until 3:40
No,
p.m.
no, Matteo,
No?
it's better to start with the other country. So because also we, the other colleagues have other commitments. So in my opinion, it's best to start with Ukraine and the Balsamo can speak after.
But
And
I think
don't lose time. So because I suppose that everybody has other commitment after and hasn't the time to.
okay, this way we or we will interrupt the Ukrainian intervention, which I wouldn't,
Because-
or we renounce the intervention by Prosecutor Balsamo. And since he can speak from 3:40 to 4 p.m. and then he will take the flight, so he won't be available.
When he's able to speak in 5 minutes,
20 minutes from 3:40 to 4 p.m. It's only availability.
okay, but he is able in 5 minutes or is only.
He told me 10 minutes, and he told me that he's available from 3:40 to 4 p.m. and this is his only slot.
So okay, so we wait for 5 minutes. Okay.
Thank you. Prosecutor Balsamo told me that he's connecting right now, so it should be here in a moment. Hi, thank you for being here, Dr. Balsamo, and the floor is yours when you want. Thanks.
Hey, thank you so much. It is a great pleasure to take part in this great initiative, which is also a wonderful opportunity to broaden our horizons, to understand the best way to achieve an harmonization in the best practices concerning the management and the disposal of confiscated assets. I would like to say something about the Italian system of management of confiscated assets. I think that the colleague Michele Fini has already introduced this object, and there is also Professor Ernesto Savona, which is together with Anna Maria Margeri, among the best experts in our country on this topic. However, I would like to say something based on the practice in this area. I think that the Italian system of management of confiscated assets is mainly based on two protagonists. In particular, the delegated judge and the judicial administrator. Both of them are appointed by means of the order of seizure, which is adopted by the court when there are reasonable grounds for freezing the assets with a view to their confiscation due to the presence of a reasonable basis to understand that there is a connection between those assets and the activities of a criminal organization or the proceeds of other lucrative activities. The judicial administrator and the delegated judge interact together in order to achieve the main goals of the administration of the management of judicial of the seized assets in the for the purpose of their confiscation. In particular, we have two main goals to achieve. The first one is to preserve the seized assets. The second one is to enhance, if it is possible, their value. In other terms, the idea of the storage of assets is accompanied by that of the increase in value of assets. Both of them are the main goals to achieve in the period between the seizure and the confiscation of the assets according to the Italian systems. And the intermingling of these two criteria is very important. In particular, we have always tried to avoid the depreciation of assets by means of a plurality of protocols that are based on the agreements between the judicial authorities and the local administration in order to ensure a participation of the civil society and all the institutions towards the main objectives of our system. One of these objectives is just the social reuse of confiscated assets. Just to go into details, when we deal with immovable assets, usually we try to ensure their availability for public or social interest purposes just during the seizure. There is a sort of anticipation of the social reuse because these immovable assets, for instance, real estate, are often given during the seizure to some cooperatives or to some public institutions that try to enhance their use and and to increase their value before the confiscation. Some of these experiences were very fruitful. In particular, I would like to mention the experience of Feudo Megnani near Caltanissetta, where in the past some meetings of the main governing body of Cosa Nostra were held. Now it is one of the best examples of use of real estate for the production of biological fruits. When we have to deal with the movable assets, we have to make a distinction. When the good is perishable, it can be sold immediately with the authorization by the delegated judge. In other cases, it may be simply kept in custody. In some cases, there was also a reuse of movable assets, for example, some vans, for reasons of public interest. For example, the emergency that took place in northern Italy due to the earthquake some years ago. Some vans were given to the public institutions competent for facing this emergency. There is also a main issue which relates to the administration of companies. It is very important to apply due diligence in order to assess their financial soundness and the possibility of continuing the economic activity. Because we have to understand that managing a mafia shareholding company is not the same as managing a legal company. It is much more difficult because a mafia shareholding company has many debts, but the creditors never ask for their payment. many workers are illegally employed. The rules about workplace safety are not observed. There are few invoices and many operations carried out without paying taxes. Many workers are linked by a relationship of mutual trust with the criminal association. And in such a situation, the judicial administrator must make every effort to run the business, but is also to make a precise assessment of the network of relationships between the protagonists of the economic activity and the mafia bosses. So there is the need for a clear distinction between those mafia shareholding companies that can have a continuity of activity and those companies that were mainly used for money laundering purposes. In the first case, it is important to continue the activity. In the second case, a closure could be the best option several times. In this system characterized the management of seized assets in the first two levels of the proceedings. In particular, we have to consider that the proceedings for the confiscation in Italy are dealt with before three judicial instances. There is a first instance trial, an appeal trial, and a trial before the Supreme Court, the Court of Cassation. The management is entrusted to the judicial administrator and to the delegated judge during the first two phases of the proceedings until the outcome of the appeal trial. After the decision made by the Court of Appeal, we have a competence of the National Agency for the Management of Seized and Confiscated Assets for the administration. However, also the agency usually takes advantage of the experience of the judicial administrator. Who is the judicial administrator? He is a professional, which is to be chosen between among those people that are included into a roster of judicial administrator. Usually is a lawyer or an accountant. In every case, what is important is that no relation should be ascertained between the judicial administrator and the owner of the company. All the members of the family of the owner of the company or of the assets, and all those people who are connected to the person under suspicion should be excluded from those people among which it is possible to make the choice of the judicial administrator. And we also try to ensure that in the case of the pre-confiscation sale of assets, should we make every effort to avoid that the person that buys the assets is a figurehead, a person closely connected to those under suspicions. As to the other issue, which is the protection of bona fide third parties, I would like to mention the fact that the Italian system tries to ensure a high level of protection of bona fide third parties. That means the creditors acting good by faith. The creditors, the persons who have rights against the owner of the assets, can initiate their good faith assessment procedure from the time of the first instance confiscation order. They can present their reasons before the same court that ordered the seizure. In such proceedings, the creditors must prove that they have ignored the criminal activities of the owner and they have not contributed to the development of these activities. It is very important to understand the need to protect bona fide third parties in order to ensure the overall legitimacy of this system, because otherwise an unlawful sacrifice of the rights of these parties could result in a lack of confidence of the community towards a system of seizure confiscation of assets that has proven to be very successful. Last but not least, I would like to mention the experience of the social reuse of confiscated assets. In the recent directive on asset recovery and confiscation, which was adopted by the European institutions and was published in the official gazette of 2 May 2024, you can find the best explanation of the rationale behind our system of social use of confiscated assets, which is a way to involve the community as a whole in the fight against organized crime by giving the communities that were affected by the violence of organized crime the benefits that we can obtain from an efficient confiscation system. I think that the change in the mindset of southern population in Italy was really helped and supported by this system of social use of confiscated assets that we try to closely connect with the administration of seized assets. For instance, we try to provisionally bring those assets that probably will be confiscated to the same legal persons that in the future could be in charge of their administration, of their management after the confiscation. And this experience of anticipation of social reuse during the proceedings was very meaningful in many areas of Italy, including Rome. There are some experiences made in Rome that are the best way to ensure a continuity between the seizure phase and the phase that follow the final confiscation. Thank you for your kind attention. I am sorry for the need to leave you because I have to come back to Palermo. Many thanks once again to Anna Maria Moggeri for her kind invitation.
Antonio, have you time for a question, or you have to leave soon?
Unfortunately, I have to leave because I have a flight to Palermo at 4:30. I'm very sorry, but I had to go to Rome today, and so I am compelled to reach the gate.
Go to the gate.
Okay, thanks so much for your participation.
Ciao, Antonio.
Many thanks once again, and see you soon.
Okay.
Ciao, Antonio.
I would like to stress that in Italy, in the so-called anti-mafia code, we have a specific part of this code or this legislative decree 159 of 2011 about with specific rule about the management of the frozen assets, about the destination, the disposal after the definitive confiscation, About the rights of third parties, their participation in the trial, in the different phase of the trial. We have a very good legislation. In the practice, there are always some problems. It is not everything perfect, no? Because, for example, when we have the seizure of a company, there are a lot of problems because sometimes the banks doesn't give any more credits because the providers don't want to carry on the relationship with the company which is under seizure. This is a problem in order to guarantee that the continuity of the economic activity, even when in any case the company is a good company with some involvement in a crimes matter, is a company which is able to stay on the market. So it is the problem of the seizure and the management of the company is the more complex issue in the end. Thank you.
Thank you very much. So I believe we can proceed with Mr. Savicheva. We had some issues this morning connected, but I see her and I presume she can speak. The floor is yours. Thank you very much. Excuse me, Mr. Savicheva? Can you hear us?
Yeah, I can hear you. Hello,
Thank you.
good evening. Yeah, hello. I'm Christina from International Department of Pharma, Asset Recovery Management Agency of Ukraine. And I hope you can hear me good because all day we have a bad internet connection because of problem with electricity. You can hear me, right?
Yes. Yes, good.
Yeah. I'm glad that there is such a platform where we can have such experience exchange. And until start to my presentation, I would like to mention that ARMA and law enforcement bodies are involved in preparing for bilateral meetings under negotiation Title 24, Justice, Freedom and Security in the area of confiscation, freezing of property, assets and financial penalties, and Title 23, rules of law and fundamental rights and freedoms, and regulation that one was mentioned before. I would like to note that interagency cooperation with state authorities and international partners is currently underway to implement the provisions of the regulation and undertake a screening of legislation to ensure that Ukrainian norms are in line with European standards. So ARMA is responsible for the state policy in the field of asset seizure and recovery. Also, I should note that in the near future, we are going to start organizing interagency meeting in the implementation of the mentioned regulation. In addition, ARMA is equipped to obtain expert support on the necessary knowledge and skills, in particular of the Authority of Asset Recovery Offices, effective asset management, centralized registers of fraud and confiscated assets in the context of the European law and the European integration, to prepare a presentation for bilateral meetings on the asset recovery. And now I would like to share a screen. I can do this, right? I can
Yes,
try at least. Yeah, because I can have some problem and still no electricity. Okay, can you help me? Probably I start. I want to present to you, and you can see, right?
No, we see a black screen.
No.
We see that you are in sharing mode, but with a no black.
Only black screen.
Yes.
Probably for not waste time, I can start, and if it's not problem, I can send you later presentation. Today I want to present you.
As you prefer. Yes,
Sorry?
we can do that.
Yeah, because I don't want to waste your time. I want to present to you information about cases related to the management of assets confiscated both in Ukraine and abroad. ARMA main functions include finding and tracing assets subject to seizure in criminal proceedings. The national agency supports criminal investigation by tracing assets upon request from relevant authority, ensuring international cooperation, filing court's claims against invalid legal acts. And still you can see, right? Because it will be more useful probably.
If you want, you can send me the presentation, and as soon as I receive it.
Okay. Okay. So if I send it to you, or it will be. Matteo, I can send it to you. Probably it will be better.
Yes, I think so, but it will take some time.
Yeah.
To receive it.
Okay. Okay, give me just 2 minutes.
Sorry?
Give me 1 minute and I can send it to you. Can you send to Matteo? Thank you. But one of the agency's important function is asset management. The national energy manages seized assets in criminal proceeding to preserve their economic value by transferring them under asset management agreements or by selling them and depositing the proceeds in the state banking system until the end of the criminal proceeding. The second paragraph of part 1 of Article 19 of the law of Ukraine, ARMA, defines that assets are taken into management on the basis of a decision of the investigating judge, court, or consent of the owner of the assets. Assets received by the National Agency for Management shall be evaluated and transferred to the management of the tender determined by the result of the competition in accordance with the procedure established by the legislation on public procurement. At the same time, in exceptional cases, assets seized in criminal proceeding may be managed by transferring them based on a decision of the Cabinet of Ministers of Ukraine. On my presentation, you can see this exceptional cases, but unfortunately, we can see them. I can send you later. I would like to share an example of the mechanism used for managing the seized Gluska petrol station. This is a really great example. Asset management based on the decision of the Cabinet of Ministers of Ukraine. Rather than transferring to management based on the result of a competition. Pursuant to an order of the Cabinet of Ministers of Ukraine in 2024, ARMA was transferred to the management Naftogaz Oil Trading. It's a limited liability company. And I want to mention that ARMA checks the effectiveness of the management of seized asset transferred into its management periodically, but at least once a month. So at the end of July 2023, ARMA concluded that Naftogaz company had not properly managed its assets. So from 2021 till 2023, the previous manager of these assets paid only near 33,000 euro to the budget of Ukraine. So can you mention this for 2 years of management? And this is, of course, not enough amount for 2 years. It's this petrol. These assets include near 100 petrol stations. And in addition to this, the manager deliberated failed to provide ARMA with the accounts details. Payments were made for sales of fuel, as well as information about the supplier and the country of origin of the petrol. So at the end of 2023, based on this result of the audits, ARMA terminated the agreement unilaterally. The next our step was that at the meeting of the Government Committee of the Cabinet of Ministers of Ukraine, at the first part of August 2023, it was decided to transfer the seized assets to the management or to another management. It's called Ukernafta. And pursuant to the order of the Cabinet of Ministers of Ukraine, ARMA and Ukernafta entered into an asset management agreement. So we signed a new agreement. And just for 5 months, Ukernafta paid near 35 million hryvnia. It's to state budgets of Ukraine. It's much more that were paid, but previous manager. But it's that I've mentioned the case of management. In Ukraine, but of course, but we have not a lot of cases management of asset abroad, because we have some barriers, some problems on our way. So I would like to tell you in short about one interesting case, in some way successful. It's case of asset realization abroad, Medvedchuk yacht. Probably someone heard this, and because there was no such example in the history of Ukraine until this interesting case. ARMA has taken many steps to sell these assets abroad. It started from the decision by Lychakivsky Card in 2022. This yacht is located in Croatia, and this is the first ever case of confiscation, namely the sale of an asset, the Royal Romance yacht, that located in foreign jurisdiction. With the assistance of the Prosecutor General Office of Ukraine and the District Court of Split, Croatia, issued a decision to allow the agency to inspect the vessel. ARMA started active communication with the competent authority in Ukraine, in Croatia, like embassies of both country, Ministry of Justice, Ministry of Foreign Affairs. So in February 2024, following an ARMA request, the government of Ukraine approved finally a competition for the sale of the Royal Romance yacht, and at the end of April, the open tender selected the seller of the seized yacht. We still on the process because world's auction houses have faced to opposition from Medvedchuk lawyers. And I just want to tell you some the main achievement, our achievements in this case. On October 2023, the Cabinet of Ministers of Ukraine, initiated by ARMA, and approved a resolution to create that special procedure for sale of seized assets abroad. So until this, we haven't got such a law that we can sell some assets abroad. ARMA was declared the temporary owner of the yacht Royal Romance, and the agency received a Ukrainian flag for the arrested vessel of the Ministry of Infrastructure, registered by the Ministry of Justice. The registry data was confirmed by the International Maritime Organization, which legally confirms the records of ship ownership in all registers around the world. So this case will be the first precedent in the history of Ukraine that will establish the mechanism for ARMA to sell the assets abroad. And now I would like to pay attention on the case that could become the first in the management, not sale, but management of an asset abroad. About aircraft. Following court orders, ARMA received the application and rulings to seize and manage the aircraft. According to the request, one aircraft located in Canada and another one in Germany, Leipzig International Airport. And so our step was like this. We, with the support of the Office of the Prosecutor General, is requesting a mutual legal assistance to confirm Ukrainian court decision and transfer the aircraft to ARMA. And here I would like to note that under Ukrainian law, ARMA is not authorized to independently request mutual legal assistance. According to this article that I was mentioned, 545 of the Criminal Procedure Code of Ukraine, such requests are made by the Prosecutor General's office during the pre-trial investigation. Regarding this practical experience in the first asset recovery case, understanding some gaps in the national legislation, and in order to reduce the time for preparing and sending relevant requests for mutual legal assistance, the agency initiated amendments to this article 545 of the Criminal Procedure Code of Ukraine, which will allow ARMA to apply to foreign jurisdiction for international legal assistance, so we can do it independently. Currently, ARMA has two methods. If you speak about the aircraft that's situated in Canada for legalizing Ukrainian court decision. We can start from legalization through Ukrainian court, or second variant, it's SEMA procedure. And argument for preferring the exception of Ukrainian court order over a country-to-country agreement on state ownership transfer. This SEMA procedure takes over 2 years, including 4 months for document preparation. So it's of course, it's a long time. And second, it's the owner may appeal a positive Canadian court decision, adding more time, and executing the Ukrainian court decision and legalizing it in Canada can implement the transfer within 6 months. But the managing of mentioned aircraft is important for Arma and Ukraine in general, especially during this hard period of time, period of the Russian Federation invasion. Despite significant achievements, we still face challenges, including resistance from those avoiding accountability for illegal actions. But Arma is open to cooperation with strategic partners to address issues and to improve our effectiveness. Thank you so much for attention.
Thank you. Thank you very much.
I'm here. I'm not.
So, is there any question for Ukraine Arma? If this is not the case, thank you very much for your intervention. And I would leave the floor to our final speech by Pavel Kalpaiu, by the Republic of Moldova. The floor is yours.
Good afternoon. Thank you for this great opportunity to be part of this distinguished event. Thank you for the presentations which were made during the day. It was very interesting presentations. Also, I want to put on to your attention to the structure of the Criminal Asset Recovery Agency from Republic of Moldova and the few cases we had based on our international cooperation. So I'll try to share the screen. For a few seconds. No, 1 second. So please let me know if the presentation is shared.
Yes, but not in full screen. So you could have some problems going through slides.
1 second. And now?
No.
No, it's not. Okay.
I think you have to restart the sharing and sharing the whole screen.
Okay.
Instead of the single window.
And now?
No, we see the slides at least. Oh, you can try to push. No, but we see the slides. So if you want to go ahead, you can. I mean.
So thank you. Okay, so Criminal Asset Recovery Agency was enforced in 2017 as an autonomous division within National Anti-Corruption Center. From that moment, in our national law, was established a few new things. So first of all, it was about parallel financial investigations. And the second part was about the asset management. So at this moment, Criminal Asset Recovery Agency has both competences on classic asset recovery offices and asset management offices. Our structure is divided in 5 subdivisions, which are responsible for financial investigations, for special investigations, for IT and analytical issues, for international cooperation, and for evaluation, administration, and disposal of seized assets. Due to this fact that due to the fact that we have both competencies of a classic ARO and AMO, we have a good internal cooperation. So when we speak about duties of asset management unit, we have a few strong points. So first of all, we are involved in procedure planning of all activities of law enforcement agencies. At this moment, we are able to provide evaluation of criminal assets, and we have both capacities for. We have our internal staff, which is able to provide evaluation, for example, for real estate, for cars, or also we have the capacity to hire or to sign agreements with independent evaluators for providing such specific evaluations, for example, for journalists. Also, we are involved in evaluation of the financial profile of the perpetrators. This kind of service is provided in order to apply seizures for extended confiscation. So one of our duties is to provide the evaluation of financial profiles of the subjects of the financial investigations. In order to preserve the value of the seized asset, we have a few tools. First of all, we are able to manage seized assets. We have the capacity to manage, for example, cars, jewelries, old books, Bibles, and different another type of goods. For example, we are able to, we have our own accounts for cryptocurrencies. We have accounts on Binance.
I'm sorry to interrupt. We are still seeing the second slide on the legal framework.
Legal. Sorry. Now.
No, it's still the second one. So I think that.
Okay, I'll try to stop sharing. That's and now.
Oh, perfect. That it's in full screen. Thanks.
Okay, and I can change it?
Yes, we see everything. Thank you.
Thank you, great. I fix it. So a few more words about the structure of Criminal Asset Recovery Agency. We have both competences for a classic ARO and for a classic AMO. Our structure is divided in 5 special units, which are in charge with, which are responsible for financial investigations, for special investigations. Also, we have an IT department, we have an international cooperation department, and we have the asset management unit, which we have called it. It's the name is Evaluation, Administration, and Disposal Department. Actually, I represent the asset management unit. We are in charge of evaluation of identified assets in order to apply seizures on them. Also, we are able to manage assets, and in some cases, specific cases, we are able to carry out interlocutory sales of seized assets, but it will come later. So about the procedure planning, we are able to provide the criminal asset evaluation of the criminal assets. Also, we are able to provide evaluation of the financial profile of the perpetrators in order to apply seizures for extended confiscation. In order to preserve the value of the seized assets, we are able to manage seized assets. So it's very common for us to manage cars, jewelries, old books, the spare parts of the computers. Also, we have treasury accounts on which we are through these accounts we are managing cash money. Also, on these accounts we are able to wire money which are seized on the bank accounts. On this moment, on their accounts, we have more than 500 million lei. It's about 26 million of euro. Also, we are able to manage cryptocurrencies, crypto assets. So we have wallets, e-wallets on on a few electronic platforms. The main of them are Binance platform, exchange platform, and Exodus. At this moment, we are managing such kind of cryptocurrencies like Tethers, Mantra, Bitcoins, Starknet, Litecoins, and many, many others. It's about 25 positions of cryptocurrencies, which were seized by Kara and was transferred on our e-wallets. Also, we are able and we are in charge of with the selling of seized assets prior to final court decisions. This kind of activities are provided in order to preserve the value in some specific cases like depreciation, or in the cases when it is very hard or very expensive to manage some kind of assets. Also, our unit is responsible for drafting policies on asset management matters. It's responsible for keeping the registry of seized and confiscated assets, and also we're in charge of the trainings of the judges and prosecutors on asset management matters. Now I want to present to your attention a case, a specific case of the repatriation of the assets, criminal assets from United Kingdom. So we're calling it Luka Filat case. He was a son of the former Prime Minister of the Republic of Moldova, who was imprisoned for 9 years for abuse of power and corruption. And I want to describe how it happens. So at a certain point, we were informed by the UK authorities that the son of the former Prime Minister had he had a lecturer's lifestyle in London. So in presentation, you can see that the car he used, and the apartment he was rented for £5,000 per month. So it's a lot of money. And we starting the negotiation. So first of all, we provided all the information about the case, also the fact that he was convicted in Moldova, and also about the fact that he was that the court decided to confiscate more than 25 million euro from this guy, from his father, Vladimir Filat. And from that moment, we were in direct contact with the liaison officer for law enforcement agencies from UK Embassy in Bucharest, and we started to negotiate about the repatriation. The first point I want to mention that one of the main condition was that money, it was about so they seized UK authorities seized 400,000 pounds in UK in a bank account, which belongs to Luka Filat, which belongs to the son of former Prime Minister. And the main point was that money, in case of repatriation, must be used for social reuse. After that, we had two options. So first of all, it was a bilateral agreement to sign with the UK, a bilateral agreement between Moldovan government and UK government. And the second option was to sign an agreement based on UNCAC convention, on the Convention Against Corruption. Due to, I think, some political reasons, it was decided to sign a bilateral agreement, and that funds, 400,000 pounds, were wired to Moldova, were recovered by Moldovan part, and the funds were used to identify and hire personal assistance for people with special needs. The monitoring of an implementation of this project was ensured by a national NGO. Also, it's important to be mentioned that this project served as a trigger for such services, and the provision of which continues today. So it was a very important project for the Republic of Moldova. Finally, I just want to mention that it was possible based also on the political will, and it is very important to have a good cooperation between the countries, which must be ensured by both law enforcement agencies, asset management offices, and last but not the least, by the government of the countries. because decisions for repatriation is based on political agreements. And finally, so if do you have some questions on this topic? We can move forward on another case.
I presume we can move forward. Yes.
So I want to present you one more case. I want to greet here Miss Antuța Mark from Anabis. So this case is about the management of the confiscated asset by the foreign court. So first of all, it's a Romanian case. So in Romania was convicted a former MP for corruption. And it was the court ordered value-based confiscation due to the fact that in mass media were information about the fact that this guy was at that time in Moldova. The Romanian colleagues asked Moldovan part to provide financial investigations. Based on these financial investigations, we were able to identify and seize a very expensive car. It's a Range Rover. It was valued. It was established its value on 170,000 euro. That is the some of the money which were paid to the company which imported it in Moldova. Like you can see on the photos, this guy made all he thought to not to be able to take under management this car, but still at that moment when we identified and seized the car was without wheels and without a key. So wheels, we procured the wheels. Also, we made the key in order to be able to ensure the efficient management of the car. After that, this car, based on our information provided to Romanian colleagues, Romania confiscated this car in Romanian court, and after that, this confiscation order was transmitted through a rogatory letter to the Ministry of Justice of the Republic of Moldova, and the last hearings was, I think, the last court hearing took place on 24th of June, a few weeks ago, and it was established a new court hearing for 17th of July. So we are waiting for a decision of confiscation. After that, we'll decide which is the best way to transmit or to repatriate the asset to Romania, or we take into consideration two options. First of all is the option to sell this car in Moldova and wire the money gained to Romania government. The second option is to transmit the car to Romania. The second option is under our consideration due to two facts. First of all, we are neighbor countries. It's not too hard to perform it. And the second one, this car is very expensive for our market. So I think the decision will be made based on the best price we can obtain in Romania or in Moldova. So it's the second case of the management of confiscated asset based on the foreign court decision. If someone have any questions on this case.
I presume not.
Okay, thank you. And last but not least, I want to present to your attention the National Asset Recovery Program of the Republic of Moldova. So this document is adopted by the Parliament in 2022, and this document is a strategic view document and establishes the development of asset recovery mechanisms in the Republic of Moldova for next 5 years. So I'll not take much more time. So thank you for your attention. And one more time, I want to thank you for this opportunity to be a part of this good event, interesting event. Thank you.
Thank you very much. That were really useful insights for us regarding Moldova. So if there there are no additional questions, I would like to, yes, Mr. Cardanon, I was about to read your the questions you put on the chat, but if you want, you can switch on the microphone and do your questions. Mr. Casano?
Yeah,
Yeah.
do you hear me?
Yes.
Thank you very much. Yes, I had several questions regarding the Ukrainian framework, and thank you very much for noticing my question, even though it's in the chat. So my first question was, from your experience, do you have any maybe experience of a turning point? I saw several modifications of the 2015 law regarding ARMA. Is there any provision or mandate that allowed ARMA to gain momentum with regard to asset management? And my second question is regarding Article 22 of the law of 2015. It's about the monthly review of asset manager that you conduct at minimal, I think it's monthly review, for their efficiency. How do you determine their efficiency? If you have any framework, I would be glad to hear about it. And also, I didn't read any sanctions or for bad management or attempt of alienation to the goods. So is there any penalties for the bad manager, between bracket, of course, bad manager? Thank you very much.
Thank you. So I ask Mrs. Savicheva if she can answer on the Ukrainian system. I don't know if she hears us. Probably not. Well, I suppose that I could circulate to her by email those questions and have an exchange with her on that if she is unable to answer.
Thank you very much.
Thank you. Thank you very much. So I think we can go proceed with the conclusive remarks by Professor Savona, Professor Maggiari. Professor Savona, you're on mute.
I will take
Yes.
3 minutes for my conclusions. I think the 2 workshops of June 19 and today are a milestone in the project which are going to end next October. Why? When we conceived this workshop, the main question to us was, what are the main obstacles for the implementation of the regulation? The conclusions of the workshop on June were the following: complexity, bureaucracy, asymmetries in regulation, and the lack of international cooperation culture. Today, I think this workshop has confirmed the last issue, which means the lack of international cooperation culture is the main variable that is producing the very low level of implementation of the regulation. Speakers have been dealing with national issues, national laws, national implementations, overlapping with the regulation. The things are totally different one from the other. But as I understand, many of the people have not read the word abroad in the title. The word abroad was clear. We want to know what is the main problem that is making international cooperation so low. One point which confirms to me that there is a lot of confusion about. In the data collection which were brought to the attention today, agencies mix national data together with the international cooperation data. I have not seen, probably I was not really capable to see, what are the difference between the number of the assets which has been confiscated abroad and the assets which has been confiscated at country level. This confirms to me the lack of a culture of international cooperation culture, which is the mixing with the complexity of the procedures. In few words, just because the project is concluding, we need to make recommendations. The main reason why the regulation is not working is a mix of the lack of international cooperation culture and the complexity of the procedures. People working in the field don't want to deal with this complexity, which is requesting more power, more energies, more attention, more culture. On the end of the story, the people try to simplify and put everything together. This is my conclusions of the today. I've been listening to all the speakers, and this is something that could be changed in two ways. One recommendation will be to simplify the procedures. Otherwise, there will be no action on this regard, which means still the criminals become international, but the cooperation does not work. The second is the following: training the people working in the ARO and growing the culture of the people working in the system. Otherwise, the level will be always very low. Thanks a lot for attending this seminar, and I was really very happy in getting this kind of confirmations that we assume what are the main issues dealing with this regulation. Thanks a lot. 3 minutes, enough.
I would like to stress one strange thing, because in one of the first workshop, the first and the second, we have some data about the application of the regulation, and each partner has given some data about some cases. One stays more, another partner less, but in any case, there are the first case of application of the regulation. So it is strange that we have the first case. They are not so much, but there are some cases of implementation of the regulation. But when we speak about the management, the sales, the case are it is difficult to find somebody who know a specific case about the management of abroad of assets or vice versa. Also in Italy, I asked to some association of administrators. Only one was able to speak me about the case of mutual recognition, but he was not able to take part in this conference. It is a workshop. Another was a case, a very easy case in Switzerland, but I don't understand who is managing these assets that are frozen of this first case of application of the mutual recognition. Maybe we are not so able to find the manager, the administrator, or the data. There is something strange. In any case, I agree with Professor Savona that there is a big problem of training, and so this is also one of the aim of the project, to give us a contribution to implement the training, to share report and so on, in order to better to improving the knowledge of the regulation and to improving the knowledge of the national system in order to improve the mutual trust. That is a fundamental element in order to improve the mutual recognition. What is important today also to stress that in the different presentation, in the very interesting presentation with the partners, the most presentation are about the case management of frozen assets, which are car, jewelry, some house, yacht, but only in the case of for Spain, there were 5 restaurants. In the other presentation, and in the presentation of Massimo, he spoke about companies, but in the praxis, there are very few cases. There are not cases in the end of freezing order and the confiscation order of that which involve companies. This is a characteristic more for the, there are many cases in Italy, but in the other member states there are not so many cases. It is an objective element. For the future, I think also that to improve the harmonization can be also an instrument to improve mutual trust, to improve in the end also the mutual recognition, but this takes time. And so, in any case, thank you so much everybody for this important contribution to our project. I stress the importance to send the presentation to Matteo in order to publish in our database. And also I would like to stress the importance to update the previous report in the light also of the new directive, because we have to publish the report not only in our websites, but in the final handbook. So it is very important for us to update the report, also with new case law, or new, I don't know, new legislation, new, in any case, it is important to update it because by September, it is important for us to have each report updated in order to realize our handbook by the end of the year. So, in any case, we are waiting for the report of this workshop. Some partners are sent, but not everybody. Every partner, and we keep in touch for the next step of the project that are more focused on sharing the results of our project, which also the other the representative of other member states. And in the conclusion, we will have our final conference in Catania in November. So thank you so much. Thank you also Matteo and Laura for the for organizing this workshop, and we keep in touch for the next step.
Thank you very much. I would like to, I'm sorry, to stress again the importance of sending the questionnaires for this WUPI, since very few partners has done so, and we need to write the deliverables based on them. And if we don't receive them, we won't be able to perform the analysis that we would like to. So just please send it. I will repeat it probably by email in the next days. Then again, the recording we will update. We will publish the recording of the workshop on our website. We will send you feedback questionnaires for also this workshop. Please fill them together with the feedback questionnaires for the previous workshop. And finally, again, if you could please send me all the presentations in order to publish them on the database and on the website of the project. Thank you very much for having participated, and see you soon.
Bye-bye.
Bye-bye.
Thanks.
Bye-bye.
Bye-bye. Nice to see you. Bye.